Уважаемые коллеги.
Dear colleagues, I think it's time we started a session. I move that we begin, and the topic of this session is known to you, I trust. Top 10 origins of post-M&A disputes. It's maybe relevant because Russia is still one of the M&A centers. And if you take some statistics, last year there were about 120 billion US dollars worth of M&As, and almost half of that is Rosneft's acquisition of 10 BP worth about 56 billion, and it is still relevant. This market is still attractive, and more mergers and acquisitions will be coming on stream. And today's presenters will be sharing with you their knowledge and experience in terms of regulating and settling disputes that emerge after the transaction, after the euphoria and media boom about this prominent events are over. Lawyers have to face a very bitter truth of the day, things that they've signed and how they should move on implementing them. I hope that today we'll be discussing various issues in the context that may be relevant to this topic, and we will be talking about minority shareholders' rights following the mergers and acquisitions deals and transactions. We'll talk about the role of domestic law. I personally had some exposure back in 1993. One of the key M&A's transactions happened here in Russia. British Petroleum bought into 50% interest in 10K, and the very first thing that we had to face was that corporate governance system for holding companies under the English law had almost nothing to do with corporate life of Russian companies. It may be ironic, but it was only down to the goodwill of the managers, of top managers, that they may pledge to and undertake to translate some of the holding companies' laws in a Russian context. And when the disputes in 10K BP arose, these things kept being discussed, and it's still not clear how these two systems of corporate governance can be reconciled, and whether some of the holding companies' standards should be made applicable in Russia. We will also be discussing the issues of translation and interpretation and understanding by councils and laws of the underlying principles under the English law in the shareholders' agreements. I trust this discussion will be quite exciting, and this kind of discussions and disputes are bound to be very versatile, and I'm sure we would love to learn from the experience not only of our panelists here, but also from the audience. I'm sure you want to discuss this topic, and I'll be very thankful to you for your questions and comments. But to start the ball rolling, I would like to give the floor to Yulia Zagonek, partner at White & Case, and Scott Cynical, partner at Cleary Gottlieb. Please, you have the floor.
We're going to talk about, Yuli and I are going to talk about negotiation and drafting points in the M&A process with an eye to the possibility of future disputes and how in the negotiation and the drafting can in some ways be symptomatic of the possibility of future disputes. Because whenever you do an M&A deal, you should be conscious that ultimately you may have to go to court or arbitration. It's one of the reasons you have a contract. Overarching points is as you go through the negotiation process as a lawyer, you should look for trends or reasons to be concerned that your negotiating process itself is predictive of future disputes. As you go through the drafting, you'll be faced with decisions on how to draft, how clear to draft, on how to address critical points, and your decisions in the drafting may open up a greater possibility for disputes in the future, or might actually, at least, if not eliminate the possibility, to circumscribe the liabilities that you run into. And the general point is that as you draft your contract, as you draft your share purchase agreement, or investment agreement, or shareholders agreement, you should always be conscious that someday a judge or an arbitrator might be reading that cold, and they won't know the context of the deal. They won't know the commercial imperatives that started the deal that you knew about as the lawyer or that your principals knew about. And instead, it will be argued by possibly a couple of well-trained QCs in London who can take every word and try to change it into a different narrative. So it's very important that every word you put down in a contract makes sense, fits together, and when read cold by an arbitrator or a judge, should not permit a lot of different interpretations, but should lead to a clear result.
And the only other point I would add to Scott's presentation, to introduction to this general topic of how important the drafting is from the point of view of a litigator or an arbitrator, as I am, I see precisely the results of the various decisions made or not made during the drafting process when the dispute arises. And one of the issues that I would identify as being very important is the transparency between the client and in-house counsel and the lawyers advising on the deal, because often there is an assumption that until something arises as a problem, it's not worth raising it, it's not worth talking about it, because it may or may not arise, and nobody particularly wants to talk about it. It might be a difficult issue, it might be something that in-house counsel feels comfortable with, but for one reason or another doesn't share with outside counsel because a decision internally has been made that this isn't an issue. And more often than not, that will be the precise issue that will arise after the deal has completed as fairly significant problem. So the need for transparency cannot be underestimated.
Looking, you may not have the slides available to you, but looking at the type of negotiations you can have. One set of negotiations I called the straight set win, a 6-0, 6-0, 6-0 win. If you're a tennis fan, you know what that means. And that means when basically you have no negotiation process. If you draft a 100-page agreement and send it over to the other side, and they say, thanks, looks good to us, we'll sign it up, you might think that's because you're a really good draftsperson, but it's probably because the other side is not very well represented or is just wants to get the deal done very quickly. That obviously should cause you to have some pause and concern that the other side is not seriously engaged or basically just wants to get a deal done, wants to get paid, and then we'll deal with the problems after that. A second scenario is what I would call the Versailles scenario, where you do have a spirited negotiation. You have a long, protracted negotiation, and you boil it down to maybe 5 or 6 points at the end. Again, it may not be the best thing if your side wins all 5 or 6 points, and thus the other side feels, for whatever reason, it had to capitulate on every important point at the end of the negotiation, especially in the context of a joint venture where you need the future cooperation of your counterparty, leaving the counterparty with a sense that they've been taken advantage of because they had some other concern, so they had to sign quickly, or that they've been outmaneuvered, or that you've won every important point and their concerns were not heard, is probably not the best thing for long-term cooperation. Another possible negotiation scenario is a deal where there is no counsel on the other side. You saw this in Russia with some frequency in the 90s. Today it's relatively rare. But what you do see sometimes is only the use of in-house counsel on the other side. And while there's some very good and great in-house counsel in Russia, if you're doing an English law shareholders agreement or a SPA, it's probably not right to have a Russian lawyer taking the lead on the other side. And again, the question would be whether your counterparty is fully understanding or committed to the deal that's being signed up. Another scenario that most of us practitioners in the room see is when principals get together and put a deal together in the back of an envelope and say, let's bring the lawyers in, let's paper that in the next 2 weeks, let's get it done, let's close the deal before the end of the year. There's always a trade-off between hitting a commercial window in a very expedited fashion where the lawyers will be up 24 hours a day for 2 weeks versus making sure you have a proper deal done. And one of your roles as lawyers sometimes is informing your principal, I'm sorry, you got to slow down a little bit. We got to get this papered right. We got to make sure the contract makes sense. So we need a little bit more time, or we're not going to make this particular deadline, which is typically a very difficult message to deliver, and you do what you can to avoid that, but sometimes it's the appropriate message to give. And then standing back from the lawyer's perspective is, as a good lawyer, understanding the commercial context of the deal, and as Yulia was saying, having transparency with your client. Now, for some clients, you may have had a very long relationship with them and you have a very good sense of their commercial priorities, but often as transaction counsel, we're brought in relatively suddenly in a deal that's already progressed, very often with a term sheet already done, and it's imperative that as quickly as possible you come up to speed with a fuller commercial understanding. So it's not just filling in a form, it's understanding what your client commercially wants to achieve and having a transparent discussion with that client. For example, if it's the seller, understanding particular areas of concern about the business and the reps and warranties, for example, so that you have full disclosure, so that you can draft for the problems that your client, who should know better than anyone, perceives can happen with the deal, looking at the different possibilities going ahead. Within the negotiation process, of course, is also a drafting process. And in most deals, of course, you have drafts going back and forth all the time. And if you look at the computer numbers, the versions, you get to the 20s and the 30s. And as the drafts come back from the other side, you are often confronted with a difficult choice, or sometimes confronted, of some ambiguity in the drafting. And if the ambiguity you think you can read in your favor, and you're in a time-pressured situation, the question, and you should discuss this with your client, is whether you live with that ambiguity, you think the wording will work in your favor, you're not 100% sure, or whether you want to go the full 9 yards and demand that you have 100% accuracy in the drafting, that you get the point exactly the way you want it to be written, which the disadvantage of which is that you'll go through another draft, And the second is that you might highlight an issue that the other side had really not focused on and will now focus on, and you'll have a contested battle over that, which you could lose. Do you want to?
Yes, I think it would be important at this point to give you an example, because often in the drafting you will find some specific references, specific wording dealing with specific issues, and then there will be a catch-all phrase. The intention there is to take account of things that you perhaps can't define, don't want to define for whatever reason. And so things like following best corporate practices might appear in an agreement. And I'll give you an example of a case that went to arbitration with a fairly surprising result based on the circumstances of that case. It was the agreement contained the best corporate practices, following best corporate practices obligation in the context of a repurchasing event. So it's fairly significant consequence. If you don't follow best corporate practices, you will be in breach, and that breach will fall into a repurchasing event. In the same sentence, there was reference also to compliance with applicable law, which was Russian law. And the argument was that following best corporate practices is distinct from complying with applicable law, which it clearly is, and that the law sets minimum minimum standards, but best practice is much more than that. And so the argument was that best practice reference was not redundant, especially in Russia, where there is an undeveloped state of Russian corporate law. There was also an argument made that that term was ambiguous or uncertain, and the party raising it said that it wasn't. And how do you define, when you have a dispute, how do you actually prove what was best corporate practice? And one argument by the party raising it said that you need to identify practices by looking at conduct of companies similar to its counterparty, and evidence to that includes evidence to how other companies within the group of that company behaved, and the standards expected by other investors in the group. And the evidence that you would be bringing would be factual evidence and evidence of expert witnesses familiar with Russian corporate practices. And so the case went on. The counter argument was that the term was too uncertain and therefore unenforceable, but most importantly, that there was no certainty because the parties didn't know what corporate practice they needed to follow. The tribunal looked at all the witness statements, at all the statements of expert witnesses, and said that the wording, the actual words, are very clear, following best corporate practices. So there is no ambiguity. And the difficulty lies in the proving of what evidence of those practices is. So compliance with applicable law is operating and managing a business in compliance with that particular law, with Russian law, as the case was. Operating business consistent with best corporate practice, however, conducting in a way that accords with how other similar businesses are conducted, and where that way of behaving, generally accepted by those familiar with the field of business in which the company was, and such practices may have the effect of restricting what a company can do, even though it is permitted by law, or conversely, may require a company to do something that the law does not. And the tribunal in that case decided that best corporate practices are to be identified from evidence of what Russian companies actually do, and not by looking at recommendations, however enlightened, as to what they ought to do. And therefore, documents such as corporate governance code or the white paper on the corporate governance code were, in Russian, were not particularly helpful, and were only helpful to the extent that Russian companies actually followed that practice. Given that the allegations that were made as to what the company did so as not to follow best corporate practice, it is a surprising result, but it gives you, again, a very good understanding how important it is not to put this catch-all provision, which you think means something, and you think, and parties probably at the time of drafting thought that corporate governance code would be good enough to show what it is that Russian companies are supposed to be doing. But the tribunal disagreed.
To me, the real lesson from that case is, again, clarity of drafting, and to drop in a phrase like best corporate practices without defining it, without giving some sense of what you mean by that, since it can cover a lot of territory, whether it's the actual practice of Russian companies or the corporate governance code, is simply poor drafting. And that sort of unintentional ambiguity, I would call it, misdrafting, poor drafting, you should not, you should not allow that to happen in your documents. I think our slides are working. That's a map of Russia, politically correct. Can we do that for you?
Try doing it that way.
So, as we're talking about disputes in the M&A context, there's some disputes that I don't think you usually expect to occur. For example, your breach of reps and warranties, usually would think you've got those right, that you have appropriate disclosure. But on the other hand, especially in a joint venture context, you can anticipate that some disputes will occur. They're almost hard-boiled into the document. And in the context of a joint venture, a 50-50 joint venture, or a minority joint venture, you have a set of reserve matters where you basically say the parties have to agree to them in the future in order to proceed. In particular, a minority shareholder might be given veto rights over a dozen or half dozen key matters, including the future CEOs of companies or CFOs or any large transaction or the annual budget. And it's predictable that over a life of a long-term joint venture of 10 or 20 years, that at some point there could be a legitimate business dispute between the minority investor and the majority shareholder. That being the case, not only should you have the reserve matters, but you should have some sort of mechanism, possibly, to resolve them. Amongst the ways you might legislate or have in your contract to resolve disputes are some sort of escalation mechanism where you decide that the people on the ground of the joint venture can't make the decision, can't agree, so you escalate it up in the organizations, sometimes to the respective headquarters, wherever they may be, in Moscow, New York, with the idea that people who are more removed from the situation on the ground might come to a more objective decision. I think escalation doesn't work usually because the people on the ground are actually more informed, and usually there is a legitimate dispute about how to proceed. Another way to resolve a deadlock is to allow for some sort of exit so that the minority shareholder has a right to put the shares, perhaps at a premium, perhaps at a discount, or stay in, or the majority shareholder has a right to buy them out. That involves difficult issues of valuation. It involves difficult issues about the minority being forced out. It might invite gamemanship so that the minority acts in such a way to provoke a deadlock in order to be bought out. Another possible resolution is the use of an expert, and you would use an expert and not arbitration. 3 arbitrators sitting in London are not going to, as a commercial matter, decide whether who the new CEO should be or what the appropriate budget is. But it is possible to have an expert resolution procedure, ideally on an expedited basis. You would take this commercial issue to the expert. The expert could be identified by the ICC. You might also provide for something that's called baseball arbitration, coming from American baseball, and the practice there where one party puts forward position A, the other party puts forward position B. The expert does not act as some Solomonic judge, but has to either accept position A position B. It doesn't try to split it in the middle. And as a result, both parties are driven to put in the most reasonable position they can and still think they can win. Another approach entirely, though, is to have the vetoes and the deadlock and have no dispute resolution mechanism so that there is no new budget, there is no CEO, the contract is not entered into. And that's thought by the minority investor to support its interests and to drive the parties eventually into some sort of commercial logic. Because for a while, the joint venture will suffer. It is not moving forward. It's frozen in this conflict. That can cause tremendous injury to the joint venture. It works probably to the advantage of the minority investor because by definition, that person has less skin in the game. And again, it can be abused. But ultimately, it might also lead to one party buying out the other party to resolve the deadlock.
And another issue I wanted to talk about is, which doesn't arise actually that infrequently, is what do you do before your deal has completed, or maybe even before you signed, where your buyer walks away or something happens. And here the question the negotiations break down because one of the parties abandons them. And here the question will be the value of clauses where parties assume, for example, to negotiate with each other in good faith or make best efforts to close the deal. And different legal systems differ in their approach to existence and enforceability of, for example, duty of good faith. And it may prevent a party from withdrawing unless proper justification is given. English law is known and actually takes pride upon itself for not having a general duty of good faith. Although obviously much of English contract law is predicated on good faith principles such as misrepresentation, duress, but the English law approach is on piecemeal basis, based on each particular circumstances of the case. And that continues to be when it comes to contract formation. So if parties fail to reach a stage of a contract in relation to a deal that they have in mind, they will not be able to argue that they have a lesser contract in the form of an agreement to negotiate in good faith. However, recent case law in England suggests that it may be beginning to creep into performance of valid and enforceable obligations. And the way that the court looks at it is by considering the good faith provision to be an implied term. Again, that depends on the circumstances, often requires where there is an element of discretion on one party or the court wants to give effect to the party's intention. There are some controversial cases. Although obligation to reach a final agreement, the parties are obliged to negotiate with each other, are still valid, and you may look at a breach of an agreement to negotiate, where a party obstructs negotiations and prevents the parties from reaching agreement, apart from the fact that it might be difficult to prove. Nevertheless, the obstruction can take various forms: refusal to negotiate, or for example, creating unreasonable delay, or making unreasonable proposals, or playing tactics, not disclosing material information, and so on. So what can an abandoned buyer do? And that's a case that I'm sure many of you have heard about, is the famous Lux holding against Midland Resources some 3 years ago, where Midland was a Guernsey company holding various interests, including shares in Zaporozhstal. And Midland agreed to sell those shares in Zaporozhstal to Lux. And under the SPA, there was going to be 20 installments, and 100% of the shares were going to be transferred on the date of payment of second installment. And the SPA required the parties to sign a more detailed restated agreement, and if Midland refused to do so, it was obliged to return all the money so far paid and pay a fine of $50 million. English law, English jurisdiction, and so forth. Shortly before the second transfer, Lux became suspicious and that Midland wasn't going to sell and sought additional assurances. and received them. Midland made those assurances. A day after Midland made those assurances, it pulled out, returned the money, paid the fine as provided for the agreement, and sold its interest to a third party, Troika Dialogue, for a larger amount of money. Obviously, at that time, it was too late to prevent the sale because it had taken place, so the issue of an injunction prohibiting the transfer of shares was not available. However, the claimant sought a proprietary claim over 160 million of proceeds of sale, so that was the difference between the price under the first SPA and the final sale price. Sought account of profit, so profit made by Midland by breaching the SPA, and damages, again, the difference between SPA price and value of shares. The English court said that there were lots of arguments, including the argument that it was not governed by English law and so on. The court said something very important that we all need to bear in mind, that when we choose English law, the parties subject to the entirety of the English system of remedies, including equitable interests. And here, the court found that in granting the injunction that there was a good arguable case that Lux had a proprietary claim to just over $100 million of proceeds of sale, and therefore the injunction was granted. And here, the behavior of Midland had played an enormous part because the court looked at how Midland willy-nilly gave assurances to the buyer just day before it jumped off the deal. And the court said the assurances were blatantly untrue and they were false. And that was unacceptable low standard of commercial morality. And this is what you must remember when you are writing that your contract is subject to English law. There may be certain concepts that are not readily apparent from the phrase that all disputes will be resolved in accordance with English law. The final issue I wanted to talk about is penalties. It's not going on the slide, but we often, thank you. I've already talked about best corporate practices, so the one remaining point is when the parties desire to put a clause which may look like a penalty or might be a genuine pre-estimate of loss. Again, by choosing English law, you are basically making yourself available to the rule of English law that penalties are unenforceable. Under English law, penalties in contracts are not permitted. Any penalty is void and unenforceable. So how do you decide whether something is a penalty or not? First of all, when the dispute will arise and one party will inevitably argue that it is a penalty, the court will look at what the parties thought at the time of entering into agreement, not when you are having your argument. In commercial situations, the penalties often arise in default interest of loan, for example, or breakup fees on deals where exclusivity undertakings are, for example, breached. The rule, the general rule, if it is, doesn't matter what you call it a penalty or you call it genuine pre-estimate, the court will look at the substance, not at your label. And it will look at what are the genuine pre-estimate of loss. And it doesn't have to be the precise pre-estimate, it may be over what your actual loss might be. But the questions that the court will ask is, was there commercial justification for such a provision? It mustn't act as a deterrent for breach, and that's very important. Was the provision extravagant or oppressive? And what was the dominant purpose of the breach? And sometimes, whether the provisions were negotiated at a even playing field. And there's a lot of case law in English courts and arbitrations on penalties. Obviously, the courts are reluctant to interfere with contract, with the intention of the parties, but they will guard the unreasonable, unusual provisions that are aimed to punish one party. One of the examples, very briefly, I wanted to give is in one case where there's a provision requiring the seller to repurchase the shares at original price plus interest at LIBOR plus a particular percentage. Was that penalty or not? If it was considered to be a penalty, it was unenforceable. But if it wasn't, effectively, the shares would be repurchased at potentially a price much higher, because by the time they were repurchased, they have gone down, and we're only looking at the original price. Here, they were found not to be a penalty for a variety of reasons, but whenever you are drafting that clause, you have to be very, very careful. And just for the sake of time, I will pass on to the, if anybody has any questions on penalties, you'll have the opportunity to ask them. And I'll pass to Scott on dispute management.
Last slide. If you recall from the Midland case, the solution they had was that one party could apparently step out of the deal if they returned the first installment of the purchase price and also paid a fine of $50 million. And the English court said, basically, that doesn't work. You're actually responsible for the loss of the deal rather than simply the $50 million. And the loss of the deal was substantially more than that, I think on the order of magnitude of $100 million. If instead of that, the contract had said, no matter what, the seller's liability is capped at $50 million plus the return of any monies received, I suspect that would have been enforced. That would not be a penalty, that would not be written as a fine. That would have capped the maximum exposure of the seller. And that leads to the last slide, dispute management. If you're conscious that your share purchase agreement might end up in court or arbitration someday, the obvious thing to do if you're representing the seller is to try to circumscribe and limit your maximum liabilities to try to make it more and more difficult for the buyer to recover. And there are simple measurements to do that by. One is an absolute dollar cap on the maximum recovery. That might be for different things, especially in the reps and warranties, where critical reps and warranties have one cap, another set of reps and warranties to a smaller cap. It's also time limitations, so that instead of having a statute of limitations of 3 or 6 years, you limit a time to bring claims to 12 months or 18 months. You also, if you have an indemnity clause, look for ways to limit the indemnity clause if you're representing the seller by eliminating recovery for the loss of profits, for consequential damages, and perhaps adding a duty on the buyer to mitigate, which duty would not exist under a full-fledged indemnity clause. This all takes us back to the point that as you negotiate, you're not only trying to get to closing the deal and getting the deal done, but you're trying to do it in an intelligent fashion so that if there is any future dispute, one, your drafting should permit as few interpretations as possible that you represent, that you've drafted on behalf of both parties to state the true commercial deal, and if you're representing the seller, to minimize the scope of damages, or if you're representing the buyer, to keep open the maximum remedies that you might have if there's been a breach by the seller. I think we have a few minutes for questions.
Do we?
2 minutes, 1 minute.
1 second.
1 second.
Юлия, Скотт, спасибо огромное за такой хороший старт.
Thank you very much for a wonderful start. This was a very detailed presentation. We understand that we can talk at length about this, but I would like to depart from the topic of today's discussion and to ask the question that I faced many times. The company where I worked was a target of acquisition many times, TNK and TNK-BP, which was acquired by Rosneft. What is your opinion about the role of in-house lawyers when such deals are concluded? Why I'm asking that? Because the shareholders are the buyers and the sellers, and in-house lawyers, most of them are managers, are representatives of management. In the first case, since this was a top secret deal, we actually were living under the shareholders' agreement that we had as a legacy from the previous owners. In the second case, we were guarantors of the obligations of the company that was being sold at pre-completion stage, which is very important. and this was already mentioned. This is the stage before the deal is concluded, and the obligations of the seller and the buyer, where their obligations are serious, and non-compliance can lead to disputes. In my opinion, the involvement of in-house lawyers in these processes is quite high, but I would like to listen to your opinion. Julia or Scott?
Talk from the point of view of a litigator in terms of identifying disputes. I don't think that it's possible to construct any deal with and identify those problematic areas without the involvement of in-house counsel, precisely the people who are the bridge between the parties making the deal, be it a company or shareholders, and outside counsel. And without that relationship, a lot of issues will fall between the chairs. And obviously, those of us who enter into transactions or assist parties in entering into transactions on a daily basis, we have our set of skills and experience, but that does not replace the knowledge that inevitably in-house counsel will have and the tremendous value that they will add to any transaction. And Scott will comment on from the point of view of a lawyer actually drafting.
As a deal lawyer, I think if you got buyer A, seller B, and target C, it depends on the circumstances. If seller B and its legal staff have a very good idea of what's happening at target C itself, then you may not, for political reasons, want to involve the in-house counsel at target C. On the other hand, they may not, or probably the in-house counsel at target C has a better sense of what's going on there. So ideally, you would bring them into the process for the reps and warranties and the disclosure that you want to have against the reps and warranties. It would also depend how much time you have between signing and closing, because if you have a significant amount of time, for example, to get antitrust approvals, then you're going to need the active cooperation of the management at target C to make sure the companies run in the way that the purchase agreement provides. So then you need very active cooperation from management, including in-house counsel. So it will depend on the circumstances of your deal.
Спасибо. Кто-нибудь еще?
Thank you. Anyone else would like to ask a question? All right. If you have any questions in the future, they will certainly speak up. And I give the floor to Ian Fagelson, the partner of Reed Smith. He has a rather provocative presentation, drafting the acquisition agreement with an eye on post-acquisition disputes. It's whether we have a bomb here or if we want to avoid it.
Switched on. First of all, I wanted to say how impressed I am that there are so many people in the room, wide awake, thinking about mergers and acquisitions when we were all up all night watching football. And congratulations to Russia in securing a draw, which England failed to secure when we played our first game. Turning to drafting of an M&A agreement, I think, and Julia and Scott touched upon this, the problem that we face as lawyers, both inside and outside counsel, is that at the time the deal is being done, most often the parties are focused on just doing what they need to do to close the deal. They don't want to have arguments now about how to resolve arguments that they might or might not have in the future. The buyer wants to get the company that they're negotiating to buy, and the seller wants to get the money, and everybody's in a good mood. They're anxious to get to the closing. Why should they spend a lot of time, maybe even wreck the deal, discussing arguments that they might never have? So what we have to do as lawyers working with our clients is to try to identify the things that are worth arguing about now versus the things that we can take risks on and maybe with full knowledge sign a time bomb, and what are the things that we really can take the risk on. At the second level, we need to think about what is the appropriate dispute resolution mechanism to select for the different kinds of things that we might or might not have an argument about. There are some things, for example, and I think Julian Scott touched upon this, where actually you can predict that there may be a dispute, but it's a dispute that can be easily or more easily and cheaply resolved by referring to an independent expert rather than having to go to a full arbitration or a full court litigation. Typically, for example, in an M&A transaction, there might be an adjustment to the purchase price that's required based upon some set of accounts, a closing balance sheet or working capital adjustment. And it's rational to at least think about whether, if we can't reach agreement on what the closing balance sheet looks like, can we not just send this to an independent accountant that everybody trusts, rather than having to go to a full-blown dispute resolution in an arbitration or in court? And I think accounting questions, very often, it does make sense simply to say that if the parties don't within some period of days agree on the balance sheet or the working capital adjustment, it'll be referred to an independent accountant. And then you need some language in the agreement to say, well, how are we going to pick this independent accountant? And a fairly normal thing to say it'll be a major accounting firm recognized internationally that the two parties can agree upon, but if they fail to reach agreement, we will ask the president of some important body to nominate the expert. For example, the president of the Institute of Chartered Accountants in England and Wales, or the equivalent in some other jurisdiction that the parties are comfortable with. If you do that, it's common also to say that the expert will be an expert, not an arbitrator. That does cut down quite a lot of the other unnecessary expense that would be involved in having an arbitration. But also, interestingly, at least in an English law context, will mean that if the expert does a really, really bad job, the party that is adversely affected may be able to sue the expert for getting the answer wrong, which of course you cannot do with an arbitrator. As an arbitrator, once you have an award, and it's pretty much final, and there's no comeback against the arbitrator himself. Oh, the slides are working. I think the next issue that people often discuss is, okay, there are some topics that we can refer to an independent expert, but what about everything else? Arguments over breaches of warranty, arguments over the non-competes that the seller entered into. Should we go to arbitration? If so, in which forum, under what rules? Or can we simply pick a court system that we both trust? And what I found is there's quite a lot of misapprehension on the part of clients, not so much in-house counsel, but the business clients, as to the differences between arbitration and litigation. I think the first misapprehension is a lot of business people think that arbitration is going to be cheaper than going to court, and it isn't. It's very often much more expensive. In the court system, for a relatively modest amount of money, the state is going to provide you with the use of a court building and the use of a judge. If you're in arbitration, you're going to have to not only pay your own lawyers, but you're going to have to pay somebody, or maybe three somebodies, to be arbitrators, and you're going to have to rent space for them to hold the arbitration in. So very often, if cost is an issue, it may be that litigation is the cheaper route. However, against that, bear in mind that the awards of courts are much easier to appeal than the awards of arbitrators. It's very, very difficult to overturn an arbitration decision once it's been handed down. So you might find that you'll get to a final result more quickly and efficiently in arbitration than going to court with the prospect of appeals all the way up to the Supreme Court or equivalent in one country or another. Also, a lot of parties don't like the idea of washing their clean laundry, let alone their dirty laundry, in public. And litigation is a very public spectacle. It's very unusual to be able to hold a court case other than in open court, with the public present, reporters present, front page news. It's possible to hold an arbitration in circumstances of confidentiality. And if confidentiality is an issue, maybe arbitration is the right solution for your clients. Also, although this depends on the jurisdictions involved and the network of treaties, but in many cases it's easier to enforce an arbitration award in another country than it is to enforce a court judgment. I mean, I think my American colleagues will correct me, but I think the United States, it's much easier, isn't it, to enforce a foreign arbitration award than it is to bring a foreign court judgment.
Well, it depends on which foreign court you're talking about. But yes, in general, yes.
Yeah. So, and another issue to think about is, okay, we might have a dispute, but what are we after? Are we after money to put our clients in the position that they should be in if the contract had been complied with, or really do we need an injunction to prevent some kind of behavior? We're the buyer. We bought a business. The seller promised not to compete with the business that we bought, and now he's opened a competing operation in some country. Those kinds of issues, maybe your best bet is to get an immediate injunction from a court in the country where the behavior is taking place or is threatened to take place. In which case, maybe what you should be writing in your contract is that in general, disputes will be settled by arbitration confidentially in a forum that's been agreed upon, but that is without prejudice to the rights of a party to seek injunctive relief in any relevant jurisdiction where the other party is committing a breach of contract that needs to be restrained by injunction. Certainly something to think about. While we have in mind the question of the seller's non-competes, what should we be doing if we're acting for a buyer and we want to get the strongest possible protection against the seller who sold us this business immediately competing against it? And I think the business client will probably tell us we want the widest protection that we can get, the biggest geographic location, the whole world, forever, or for thousands of years, or 25 years, whatever. What we have to explain to our clients, and we have to take advice from experts in the relevant jurisdictions, is that most countries, the laws of most countries, will rule a provision that is restrictive of competition as unenforceable unless it's reasonable in the circumstances. And certainly in the English system, that means reasonable not only between the parties, but also from the standpoint of the interest of the public in having an open marketplace with completely free competition. And you sometimes see a negotiation in which the seller is over-aggressive, in which the buyer is over-aggressive and seeks the widest possible protection from competition from his seller. And the seller, who's been advised by his counsel, simply saying, fine, sign that. I'll give you the whole world in 25 years because I know it's not enforceable in all the places where I'm thinking I might want to compete in 3 years' time. So clients need to be counseled with the benefit of advice from the relevant, from counsel in the relevant countries as to how aggressive to be. Because if you're too aggressive, you end up with a provision that the seller signed, but which is not enforceable against the seller. Another issue that has to be negotiated, it never goes away, is how are we going to frame the basis of liability in case there is a breach of the representations and warranties by the seller. What should be the upper limit of liability and what should be the lower limit below which we don't care? And here I think, again, American colleagues jump in if I've misunderstood this. It seems to me that the tradition in an American-style agreement is very different from in an English-style agreement. The starting point has historically been, if you're doing an M&A, a share purchase agreement or a business purchase agreement, and both sides are represented by English counsel, it's almost a given that the upper limit on liability for breach of the representations and warranties will be the purchase price. That is, if everything I told you about the company in this contract is not true, and you've suffered loss as a result, the most I'll have to give you is your money back. But I think the American approach is to cap the liability much lower than that, for it to be a percentage less than 100% of the purchase price.
Certainly in Russia, I mean, you would argue, you have this argument every time in Russia, and I would say the range is from 10 to 100%, and usually 100% on just a few critical warranties going to title, making sure the shares you say you own, but in terms of the broad set of company warranties, the accounts, the material contracts, you will bicker from somewhere between 10 and 100.
Right. Whereas, so if you're a Russian, representing a Russian company buying from a UK seller, you should be reasonably confident that you can set the cap at 100% for everything, and your UK seller's counsel will probably just agree to that. On the other hand, if you're representing an English buyer of a Russian company, you may have to educate your English buyer to accept something a little less than that, you would see. You also argue about, okay, we know what the upper limit is going to be, but surely there are some claims that are too small to even bother about litigating. And what we tend to do is we tend to think of a really small number for items which are too small even to think about, and then a much bigger number, but still only a small percentage of the purchase price, that claims have to reach before the buyer can make a claim. And there's, again, usually an argument, not a long one, as to whether, once you reach that figure, is it what we call a basket or a threshold? I'm sure you're probably familiar with these concepts. But if it's a threshold, then you can only sue for amounts above it, whereas if it's a basket, once the basket is full, you can sue for everything from the first ruble. And again, I'd be interested to know from you what's common in Russia, or from you.
I would say the standard approach is first dollar, the basket.
Yeah, which is the approach in Britain. So at least on this, we're the same. There's also a kind of routine ritual dance that you have that always comes out pretty much the same way, which is how long do these warranties last for? How long do I, as the buyer, have to look seriously and closely at the company I just bought and bring a claim that all the warranties weren't true, or some of the warranties weren't true? And I think what I see emerging now as a pretty much consensus across the various countries that I've dealt with is that for ordinary business and financial warranties, the period should be enough to cover 2 audit cycles. So depending on when in the year you close the deal, it could be up to 3 years to get 2 audit cycles. But issues that are not ordinary business issues, but are connected with how quickly governments respond, you usually get a longer limitation period. For example, tax claims. It's very common to have a period of liability for tax warranties and indemnities, which is much longer than 2 audit cycles, because tax authorities around the world usually wait until the last minute before they decide to bring a claim against a company. So very often you see a contract, at least I've seen contracts, which say that the survival period for normal warranties is whatever you need for 2 audit cycles, but for tax warranties, it's the maximum period that the tax authorities in the relevant countries have in which to make claims against the target company. And finally on this point, there's usually some discussion about should there be any exceptions to these limits on liability. And typically, what I see, at least in deals that are documented under English law, is that you will have an exception for fraud. That none of the limits, not the time limit, not the upper limit on liability, will apply in the case of a fraudulent breach of warranty or misrepresentation. But you often see other uncapped arguments for removing the cap. Very often, if there's an American player in the deal, they'll say there should be no upper liability on environmental liabilities, or no time period limit on environmental warranties. And also, you see the argument made that there should never be any exceptions to warranties that are given about title to the property being sold. Oh, I've pressed the wrong buttons. Technology challenge. There we go. I think one other thing that needs to be thought about is, and this comes back to the very first point I was making about, are there arguments that you need to have now, or can you actually defer them because you might not need to have them at all and you can have them later? And that, I think, comes home most into the sharpest focus on the question of, do we need indemnity language in our contract? You know for certain that if you put in a contract, not only is the seller making these representations and warranties, but if they turn out to be untrue, the seller will indemnify the buyer. That leads to an inevitable and sometimes very long and expensive debate as to what are the terms of the indemnity, exactly how do you calculate what's being indemnified, will the seller, if the indemnity involves a claim against the target by a third party, will the seller have sole power? After all, if he's paying the indemnity, should he have sole control of the defense of the third party claim or the negotiations for settlement with the third party? I mean, these are big debates. They can take quite a lot of negotiation time. And sometimes, although Julia, I know, is going to disagree with me, sometimes it makes rational sense to say, you know what, chances are we're never going to have a dispute. If we do have a dispute, if we choose English law, there's a very well-developed set of legal principles that the English courts and English arbitrators will understand about how you calculate damages for breach of contract, the buyer's obligation to mitigate his loss, what kind of loss is too remote, whether loss of profit is within the ordinary scope of contractual damages. And it can be, though I'm open to being persuaded otherwise, it can be a completely rational decision to say, to leave the contract completely silent on the question of indemnity for breach of warranty, and to say we trust the courts if we have a dispute. We don't want to spend this money now, we'd rather spend it then. And that's pretty much my 5 or 7 minutes used up, but I'm happy to answer any questions.
Спасибо, господин Фагельсон.
Thank you very much, Mr. Fagelson. The first presentation was mostly on how avoiding disputes. Now you've got some practical advice how you should act if you have to go to court. And the very first issue to consider is what you want to, where you want to litigate. Should it be court or should it be arbitration? We heard about injunctions and the need to get them as soon as possible and to consider the enforceability. Commercial arbitration courts are acting quite promptly in the injunctions, but the issue is almost always enforceability. And then you only have to rely on the good faith of the other party, whether they would comply with the injunctions against them. But we had very useful pieces, practical pieces of advice, and I'm sure we will have the benefits of Jan Fagelson for some time for your questions. But now I would like to give the floor to our colleague Tamahira Tsuchiya. He will be talking about breach of warranties and guarantees, and it's one of the most important issues post-M&A negotiations. I'm sure will benefit from his experience. You have the floor, Mr. Tsuchiya.
So I'm discussing the several issues arising from the seller's breach of warranties. I think I'm the only Japanese lawyer in this room, so I sometimes have to refer to some Japanese law and practice. So maybe it's not so interesting to you at this moment, but just take it as information just in case you happen to have a chance to deal with the Japanese business. So yeah. A number of issues can be discussed for the breach of reps and warranties, but I want to pick up the three issues for this discussion. The first, the lower financial performance of the target. The second, so-called sandbagging issues. And the third, the reduction of the target value. The first one. So it's not unusual after the acquisition by buyer, the target's financial performance is worse than expected. If the buyer wants to be indemnified by the seller because of such low performance, how can the buyer challenge the seller? What can be the ground for the buyer's claim? The problem is usually the seller will not make any representations about the target's future performance. The seller's reps are basically the statement of facts only existing at the time of the signing of the agreement and the closing of the deal. So buyer may consider several provisions if we want to claim breach of seller's representations regarding the target's low performance. First, seller usually makes the reps that the target's financial statements fairly describe the target's financial conditions and there's no liabilities that were not disclosed in the target's financial statements. The buyer may claim that the reason of the target's poor performance is any liability undisclosed in the target's financial statements. Second, sometimes the sellers agree to represent that the target has sufficient assets to operate its business in the same manner as the target did before the closing. Therefore, the buyer may say that the assets acquired were insufficient for the target to operate the business. However, the seller is usually very reluctant to make such sufficiency lists because it's very broad and ambiguous. Finally, the seller may represent that the seller has disclosed all material information about the target and such disclosed information is true and correct. So the buyer may claim that such lower performance is kind of a surprising information that was not disclosed to the buyer before the deal. Actually, the disclosure lapse kind of works as a last resort for the buyer when something unexpected happened after the deal. But this means that it's quite difficult for the seller to accept such kind of catch-all lapse. And even the seller agreed to put kind of a disclosure representation. In many cases, the scope is very, very limited. The next topic is so-called sandbagging. The issue here is when the buyer already knew the breach of the reps or the information constituting the seller's breach was it disclosed the buyer in, for example, in the due diligence investigation. Can buyer still claim damages for such breach of representations? In this regard, the Japanese court recently held that the buyer cannot claim damages arising from the seller's breach of representations if the buyer knew or failed to know by gross negligence about inaccuracy of the seller's reps. Since then, particularly in Japan, the buyer always wants to put the so-called sandbagging provisions where the buyer's knowledge about the breach does not affect its right to claim. And of course, the seller wants to go the opposite way. It means that they want to put the totally opposite provisions where the buyer will lose his right to claim if it knew the breach. The seller will be protected if he can prepare an extensive disclosure schedules describing exception to its representations. But sometimes it's quite difficult to prepare such exhaustive list in a very limited time frame of negotiation. And also, maybe the court said that the interpretation of the sandbagging provision should be quite limited because of the principle of the fairness or the kind of a public moral or something like that. The final topic is, if the target paid money due to an event constituting seller's breach of representations, how should the buyer calculate its damages? There will be two possible approaches. The one is that the damage will be the money actually paid by the target, and the other is the damages will be the difference between the re-evaluated value of the target and the purchase price paid by the buyer. And with regard to the first approach, it's clear that the amount should be adjusted if the buyer acquired only a part of the target shares. Furthermore, it might be difficult if the target value is calculated by, for example, some DCF method. The full amount of the target actual payment or the re-evaluated value can properly reflect the buyer's damage due to the seller's breach of the reps under warranties. So this is the end of my presentation.
Спасибо. Ну, как мы...
As we saw and heard in the presentation, due diligence is a very important phase in mergers and acquisitions, and also the depth of the disclosures, the representations from the buyer is of critical importance. And herein lie many problems for the future situation. Typically, the buyer only executes due diligence of the financial statements and liabilities, but there are many hidden points that can emerge later. For instance, current lawsuits that are estimated as not very consequential can lead to court rulings that will impose huge financial obligations upon the target, etc. So due diligence is no easy matter, and perhaps it is a central point in any M&A transaction. I'm now happy to give the floor to our next presenter, Yelena Popova. Her subject is M&A deals involving Russian companies governed by foreign law. This is a subject that needs to be further studied and elaborated.
Yeah, and sorry,
Thank you, colleagues. I will be speaking in Russian. Our topic is M&A disputes and issues that arise when foreign law is applied to them. I'm sure many of you will know that over the past 10 years, most large M&A deals with regard to Russian companies were structured with the use of foreign holding companies. But for various reasons, including political ones, many of such deals involve a direct purchase of shares and stocks in Russian companies, and often the need arises to apply foreign law to such situations. The issues here are the same as in any other kind of M&A deals: structuring, the complex situation, the time difference between signing and closure, and delay clauses, and the need to prescribe pre-closing obligations and post-closing obligations. The standard practice is that the buyer expects to have the same means of protection, such as representations, warranties, and indemnities, and that's why foreign law is often resorted to, because there is an arbitration clause included. All of these business issues have led to a practice of structuring Russian deals with support legal structures under foreign law. And that is my subject today. And I'm going to look at possible disputes and issues that can arise there. Before we speak about the disputes, let me step back a little bit and talk about the limitations that are part of Russian law that can affect the structuring of a deal, especially when it comes to acquiring shares in Russian joint stock companies. You're all aware that deals involving shares in Russian companies are governed by Russian law, which requires certain steps, such as notary certification, and the need to prepare the document in written form as a single document. The law also prescribes the content of the deal. The time of change of title is prescribed in the law and cannot be discretionarily changed. The notaries are also, Russian notaries are not used to working with large complex contracts. They're more used to two-page things. Another issue is conditional deals. Conditional deals under Russian law are only possible where the conditions cannot be affected by the parties. Only such deals are enforceable. Representations, warranties, and indemnities requirements, well, I will not dwell upon that. You know that these institutions are simply not present in the Russian law per se. We are all expecting changes in the Russian law, but we can be sure it's going to work identically with Western legislation. And one more thing, perhaps the key limitation that affects future disputes is everything that applies to the applicability of foreign law and arbitration clauses. Certainly there is no impossibility, no prohibition in the law against that. But the practice shows that everything is not quite so straightforward. Russian commercial courts, when they look at deals, look at primarily the following things. They see deals involving the acquisition of shares in Russian companies as connected with Russian law, and they limit the situation to the imperative norms of Russian law, which must apply even if foreign jurisdiction is chosen. Judicial practice shows that if an SPA regulates the internal intercorporate relations of the parties, but pre-closing, post-closing obligations are often involve just that. However, Russian courts view these as such as can be governed by Russian law alone. Applicable law limitations come under the provision of the Civil Code, which does not limit it to the domicile of the parties, but it's always Russian law that they insist upon. Deals for purchasing shares in Russian joint companies come under the rulings of Federal Notary Chamber of 2009, which insists on Russian law and nothing else. A few more points is whether or not disputes that can arise in the future is arbitrable or not. We know that there is Article 33 and 258 of the special jurisdiction of Russian state commercial courts, until the 1st of January 2012, there was very narrow room for maneuver. There was a formula that used in court, considering the nature of the dispute and the nature of the award of commercial courts, the dispute can be arbitrated by the commercial courts. So in simple language, that would mean that any disputes involving prices, this could be judged by arbitration, that is commercial courts. Anything involving titles of ownership, it had to come under state courts. However, the ruling of Russian FAS on Maximov versus Novolipetsk metallurgical agglomeration made a difference. The dispute involved nothing but price, but the Russian commercial court said that it had to be the Russian commercial court that could rule over it. However, when it comes to enforcement, and then the issue arises of whether or not it is enforceable. And the practice shows that it is not, and such awards are simply not enforced, such rulings are not enforced. Before we talk about specific disputes, let me also talk about the existing practice of formulating the contracts, given the limitations that I enumerated and the business tasks that are relevant here. Many of you will know how such deals are structured. there is a practice which dictates that support contractual clauses can be included in the contracts, which exist in two forms. One form is a framework agreement. That's a large, complex agreement, comprehensive agreement, typically under British law, with all their representations, warranties, and preconditions. And there is a small, short attachment, the sale and purchase agreement under Russian legislation, that is judged as the technical documentation of the transfer of shares, the ruling of transfer. The strong and weak sides of this approach are pretty obvious. The parties have great leeway in structuring the deal the way they want. For instance, they can have a time difference between signing and closing. The weak side, the downside here, is that while both the documents, the Russian sales and purchase agreement and the English law SPA, are regarded as one agreement, where part of it is under Russian law and the other part under British law, and many provisions are duplicated. There is a second version, a second approach, which I favor personally. The contract is formulated under Russian law. It's certified by a notary. It's a simple, straightforward document. But at least it's a single document which describes the sale and purchase. At the second time, a deed of warranties and indemnities is concluded, a standalone document that addresses nothing but indemnities and warranties. Both of these documents are regarded as separate. One is about the sale and the other is about the warranties. The downside of this arrangement is that such structuring is only possible if there is no need to put any time difference between the signing and the closing, and the notary certification is the time of enforcement. Now about the specific disputes. Given all the limitations that I described, and given the currently existing practice of documentation structuring, great risks arise, risks of disputes that depend on what kind of law can be applied and the arbitration clauses therein. The risks involved depend upon the conflict between the contractual documentation under Russian law and supporting documentation under foreign law. Judiciary practice shows that one of the parties, typically the seller, can abuse the situation, taking advantage of the complexity of the structure and its vulnerability. So instead of going to a foreign court, the abuser goes to the Russian state commercial court and appeals that, claiming that only the simple sale and purchase agreement can be enforced, regarding the two documents as totally separate and unconnected. The second situation that can give rise to disputes is the fact that this documentation does not conform to Russian imperative law. Russian commercial courts will look at the complex agreement and try to agree it with Russian imperative norms. Thirdly, if the case is considered under foreign law, then the issue of representations, warranties, and indemnities will come out. If you ever had to represent such a case before a Russian commercial court, you will know how difficult it is to validate the existence of these provisions. The Ministry of Justice applies a special procedure to prove the existence and applicability of these warranties and indemnities. That's very, very complex. A deal can be shattered by a dispute about to what degree Russian and foreign law applies to a particular deal and how valid an arbitration clause included is.
All these aspects endanger many deals. Sometimes lawyers remember that when they prepare documents, but that has to be taken into account. This is a systemic problem that cannot be solved on the level of drafting. This has to be taken comprehensively. To end at a more cheerful note, some of the possible solutions. I think that to eliminate the risks of collapsing the deals by unscrupulous parties is probably impossible. But the right decision, if it's necessary to use foreign documentation, foreign law, foreign institutions, it will only work well when the seller has assets abroad. So the arbitrage clause would be possible to enforce for foreign assets, so that the deal wouldn't be connected with the Russian territory. And the other recommendation, also quite well known and not new at all, it's very good to use the institute of third-party warranties. When the obligations of the seller regarding guarantees and indemnities would be guaranteed by the pledge of some other ultimate beneficiary or some other party, or if there are several sellers and one of them is a foreign company, the documents say that they have cross pledges for each other. What is the positive outcome of that situation? There is a certain positive legal practice in Russia that such disputes are not corporate disputes, and they do not have to be under the Russian law. They do not have to be reviewed by arbitration tribunals. The good news here is that the warranties and warranty and representations guaranteed by pledges were enforced by Russian arbitration tribunals. And looking at framework agreements for their adaptation for Russian constructions, for Russian law systems, many people recommend to explain that all these are material fundamental conditions to have certain cross-referencing to certain institutes of Russian civil law, so that in the case of pleading a case in the Russian arbitration court, it would be possible to found the position. Well, that means that we're actually saying that it's impossible to sell shares within Russian jurisdiction. I'm not a very naive person, but I think that there is a future for this institution. It's not a very it's a perspective that is not very close by. We have to see it as a complex of applicable jurisdictions. But in certain cases, when certain events occur and when certain efforts are taken in the future, it will be possible to solve such problems through using Russian jurisdiction, both for SPA and for SHA. This situation describes the case when the object of a sale is a share of a Russian emittent. M&A deals usually in Russia deal with offshore companies. A question arises, something that will be discussed by our next two speakers, the rights of minority shareholders. Because when offshore companies are being purchased, there is a transfer of secondary control, and the minority shareholders are in Russia. So their rights are endangered in M&A deals. In this context, I give the floor again to Tomohiro Tsuchi and his presentation on the rights of minority shareholders under M&A deals.
I think considering the time, I think it may be prudent to raise just one presentation here in my part, and I will skip the second the topics. I just want to talk about some veto rights of the shareholders under the shareholders agreement. In Japan, like other countries, the shareholders agreement of the joint venture have been held valid and binding. But we need to know that the shareholders agreement only have some contractual effect, and any action breaching such a veto right is still valid and binding. For example, if the shareholders agreement provides that the certain material matters of the company cannot be resolved without minorities' prior approval, the board resolution without such approval will be still valid, and minority shareholders cannot argue that the board resolution is void. The minority can only claim for damages from the breach of the agreement by majority. But the problem is that it's quite hard for the minority to prove that they are suffering from such kind of a minority damages from such breach of the agreement by majority shareholders. So if you want to make such action invalid, you need to provide such veto rights in the company's articles of incorporations or bylaws. But I'd like to note that the certain veto rights of minority may result in a financial consolidation of the company, if such rights are regarded as minority's substantial control over the company. Also, if the target is a listed company, the major terms of the shareholders' agreement, including the veto rights, must be disclosed in accordance with the security regulations. Thanks.
Спасибо. И тему продолжит Олег Мальский, партнер.
Thank you. Oleg Malsky from Ukraine, a startup company, will continue with this topic. Good afternoon, colleagues. Minority shareholders, if they remain in the deal, in the structure, they have certain rights. Usually, this is the veto for certain decisions, sometimes the possibility to participate in managing, the right for information, and if any condition occur, this is the right to depart. This is the right to go out. If, for example, something didn't happen as it should have. The minority shareholders can defend their rights by certain tools. These are different kinds of rights. The rights of the minority shareholders that they have by law, and the rights that they have according to the drafted documents of the company. If, for example, the acquisition happens at the upper levels of holding companies, the legislation of such countries provides certain mechanisms for minority shareholders which enables them to defend their rights. What a minority shareholder can do. I have a rather controversial topic. If a minority shareholder wants certain protective measures, is this tool adequate, or it can be abused? If a minority shareholder wants to protect his or her rights from the point of view of the legislation, they can go to the arbitration court if the transaction documents provide such conditions, or to the court and receive certain protection measures. For example, injunction to change the documents, injunction for changing the management, injunction for alienation of certain assets or concluding certain deals, certain actions, or in more severe forms, or appointing an arbitration manager who has 100% of managing the holding company, all other subsidiaries, and arresting the assets. In practice, what is the effect of such protective measures? On the one hand, formally, it is preserving the status quo of the minority shareholders. The minority shareholders want to freeze a certain structure before the question is solved by the court or by the arbitration tribunal. But there is another problem. What does the minority holder want? Sometimes they want their rights to be restored. Sometimes they want certain compensation. Sometimes they want out. And if they want out, then using certain injunction measures, they can either renegotiate or raise the price. Or if they want to remain in the structure but have better rights, sometimes this mechanism is used to reach a new agreement. Where do we draw the line? Where such injunction measures are completely adequate? When they become abusive and damaging to the joint business. I think the solution is in two aspects and two planes, if you like. One is the burden of proof. Who must prove that this or that measure has to be applied? I think the arbitration courts and regular courts in holding jurisdictions have to take all facts and factors into account. Often such measures can be done on ex parte basis without calling the other party. In that case, they are very difficult to get rid of. Outside arbitration manager as an injunction measure also requires some really blatant proof of the necessity of such a step. The duration of the process is a key factor in abuse of such measures. If the arbitration is rather long, a year and a half, 2 years, 2.5 years, then the injunction is no longer simply an injunction. It has to be reasonably long. If it's for 3 or 4 months or half a year, it's understandable. If it's imposed for 2 years, this is too long. This can give one or the other party unreasonable preferences. If a measure is too aggressive for a given situation, again, it might be a tool for abuse. In practice, the time is a major factor when the parties decide whether the minority shareholders would ask for this or that injunction. Transaction documents should try to solve this situation. This is an innovative approach, but it's possible to agree that once court proceedings start, this becomes a reason for a discount for the sellout price. Something like the pull for, like a pill for the hostile takeover. It's rarely used. The legality of this approach is disputed. In practice, the issue of post-M&A injunction measures is quite interesting. In one case, we were on the side of the minority shareholder, which didn't have enough basic reasons, but thanks to the injunction measures during the 2-year trial in several jurisdictions, the minority shareholders managed to keep control of the enterprise for 2 years. The measures were taken by were applied by different courts and so on. Basically, the minority shareholder was controlling the enterprise for 2 years and then lost. In another case, we were presenting the majority shareholder, and the minority shareholder was suing ex parte on the Isle of Man, and we had to use the national mechanisms when the enterprises are in Russia and Ukraine, and they do not acknowledge this arbitration manager. We had to prove that it was done in vain because of the proof, the burden of proof that was provided. The minority shareholders have to understand that they have to support their teams in at least 2 jurisdictions, both in the holding company jurisdiction and in the national jurisdiction, where this measure will be enforced this or that way. We can't escape from this issue. What is important here? Information and documents. From on whichever side you are, you need to have a good paper trail, correspondence, communication between the sides, between the parties, to prove the necessity of an injunction or the necessity to remove the injunction when you will have an appeal date.
The topic of the session is quite interesting, and I wanted to enumerate top 10 reasons or causes for M&A disputes based on minority shareholders, injunctions used, and this is just only some of the post-M&A disputes. I would segregate all of them in 2 groups. When you buy into 100% and when you have minorities left, and in which case the post-M&A disputes will be translated into disputes with minorities. In the first case, in the former case, you'll have a very simple, straightforward transaction. You may have a dispute over the title. That doesn't happen often, but does happen. But there are many more disputes around breaches of disclosures, warranties, and representations. happens when you buy into something that proves not to be what you thought. And again, things that have to do with prices, with pricing, which is very complicated. When you have another shareholder, then disputes usually are about the joint running of the business. Somebody must have promised something to invest into capacities, pay out dividends. This is the issue of the situation of joint operations. And then corporate governance, that is about control. Non-compete clauses, again, happen both in non-100% bargains and when you have shareholders' agreements. And finally, the squeezing, which often leads to minorities disputes. Well, this is basically all I had to say. Thank you very much. Thank you very much for this kind of closure. The very first speaker, you were the very first speaker to try and determine the top 10 reasons for disputing. As for the post-M&A disputes, minorities are usually not in holding companies. They're usually to be found in the local jurisdiction, and they will find it difficult to litigate with holdings jurisdiction. Although I had an issue with a minority in a local company tried to get injunction against a holding company, so it happens. But I would like to give the floor to next presenter, Robert Jotka. He will talk about his own experience in the Baltic republics in the context of M&A disputes.
Hello, first of all. Dear ladies and gentlemen, how many of you do not understand Russian? If you could raise your hands. 2, 3, 4. Russian. So, okay. So, because that was a dilemma, which language I should do the presentation in. So as I understand, most of you are Russian speaking, so I will try to do it in Russian in order for you to have a more with that. And I would also like to have the slide, changer. Thank you very much. Well, essentially, I'm, as the speaker, as the moderator kindly introduced, I'm from the Baltics. I'm myself from Lithuania, representing our Baltic law firm Varul. We are based in all 3 Baltic countries. And I will give you some slides showing some statistics, which would wrap up everything what we just discussed here today. Так значит, если перейти на русский язык.
Well, I'll switch to Russian. Then my presentation is more or less about the statistics and how is happening in the Baltic republics. When we discuss M&A disputes, only 5% of all transactions in the Baltic countries lead to disputes, which means that Baltic jurisdictions are rather calm and quiet and do not give rise to numerous disputes. The concepts that we have been discussing here today, of the principles of the international M&A laws enforced and accepted in Latvia and Lithuania. Local courts are rather knowledgeable about these situations, so we don't seem to have significant issues of structuring, or everything is based on international law. In terms of targets, only 13% of all targets that were sold in 2013 were distressed. In the majority of cases, the target company was a proper business, well-functioning business, and as a result, there were very few disputes arising. In terms of the structure of the M&A process, as you can see, over 80% is based on negotiated sales. It is not part of the controlled auction process, but rather private equity negotiations between the buyer and the seller. In terms of the governing law in the Baltics, more often than not, local law is used. If the target is Lithuanian, then Lithuanian law. If it is an Estonian company, then Estonian law. And our laws accept fully all the Anglo-Saxon concepts and rules governing M&A, so local laws is opted for as a result. How do we proceed with dispute resolution, and how our M&A contracts deal with dispute resolution? As you see, the absolute majority, 75% of all disputes, are resolved through arbitration. Courts deal with only about 25% of all disputes arising, and this is a significant trend. And as a result, the case law on M&A disputes is confidential, not public. Only some of the cases that were significant were taken to courts and were resolved through litigation in courts. In terms of the fora of arbitration, parties opt for local, either Vilnius Chamber of Commercial Arbitration or Tallinn-based Chamber of Arbitration, or they may opt for the Stockholm Forum, which is quite a frequent choice of the arbitration jurisdiction for the Baltic republics. Now on some general patterns, for example, the form of consideration. Well, it is cash almost in all cases, while exchange of shares is very, very rare and popular. So basically, the M&A is all about selling and buying, and cash is the key type of consideration. Now, when the purchase price is paid, in the majority of cases, it's done in a lump sum payments. As of the closing day, there could be some deferrals or runouts, as you can see, and different options are still available. But earn-out as it is, for 100% straightforward earn-out is rare. There will usually be a combination when some consideration or some price is paid out, and then a deferral is allowed for the parties to follow on representations and warranties and wait for any breaches. Price adjustments at closing, where the price is adjusted at the closing, happens quite often. However, in quite a lot of such transactions, M&A transactions, this is not the mandatory practice. 73% of M&As didn't have any price adjustments. In the rest of the cases, the targets for which the adjustment is carried out is either net debt or net working capital. These are the two key criteria that are used to calculate adjustments, if the price is to be adjusted at all. And as you can see, the beneficiary party is more often the buyer. As for the closing, the transactions are usually closed on the premises that this closing is is done based on all conditions precedent fulfilled. So this is the mandatory requirement. So as a result, our contracts do not have long lists of these conditions precedents. And of course, as for the clause on material change, it is quite often quite popular. But even in this case, in more than 15% of cases, no such clauses were included. Now on liability. This liability is usually limited based on the same principles as elsewhere. That is based on de minimis, and over 50% of all M&As had some clause limiting the liability in this or other way. As for the thresholds, that is in case of liability claim, these thresholds are rather low as a percentage of the purchase price, sometimes less than 5%. As for the cap liability, in our countries, the Baltic Republic, it could reach up to 50%. This is the most frequent case based on the statistics. Over 50% of cases you would have this cap limit established. However, about 40% of M&A transactions had 100% liability limits. And this is quite a possible situation because our M&As are quite small. We heard about sandbagging, and sandbagging is known to our countries, but it is not popular. Majority of contracts won't have any sandbagging clause, and of course you know what sandbagging is. This is a certain clause in the contract which covers a situation whereby the buyer would know something that might have some implications or consequences resulting in a breach of warranties or representations. So they close the transactions anyway and then try to claim some liability from the seller. Only 7% of all transactions had this clause, whereby the seller, by the buyer knew about the breach, but didn't say anything during the closing. So this happens, but doesn't happen very often. Most of the contracts are silent on sandbagging because this is all the thing for negotiations. It's easier not to formulate anything in the contract. As for the judiciary litigation practices, courts believe that if the due diligence was completed, it is the problem of the buyer if they had any issue. Now about shareholders agreements, while previously almost all of M&A transactions provided for shareholders agreements, but as the financial situation improved in the countries, over half of all basically provided for no shareholders agreements. And this is a very crowded slide which describes what sort of clauses are usually included in shareholders agreements. That takes me to the end. Thank you very much. Thank you. It was quite interesting to know. And we see this positive pattern in M&A transactions, and the sort of stability that we could see in the statistics seem to point to the good faith positions of both parties to the M&A in the Baltic countries. To complete our discussion, I would like to give the floor to Joseph Brand, and he wanted to talk about the client's perspective.
Thank you, Igor. I will be very brief. You will be glad to hear. What you've heard today is a seminar by M&A deal lawyers, and you've heard it from A to Z. They've done a great job of outlining all the issues you would find in an M&A transaction. I would like to give you the perspective of a client, because my law firm has just gone through a merger, and some of the lessons learned in that process. My law firm, Patton Boggs, was a law firm of roughly 400 lawyers. We have been merged with Squire Sanders, which was maybe 3 times larger than our firm, into what is now called Squire Patton Boggs, a law firm with 43 offices in 21 different countries. We, Patton Boggs, needed the merger. Squire Sanders wanted the merger. So the best way to solve disputes after a merger is not to have them. And the first way not to have disputes is to make sure it's a good deal for both parties. In this context, it was a good deal for both parties. They badly wanted the Washington practice we had. We badly wanted the worldwide footprint they had. So it was a good deal for both parties. But beyond that, the due diligence process, which took 5 months, 50 SWAT teams, and roughly 150 partners of the 2 law firms, analyzed every single issue, looked at every single liability, went to outside law firms to give each of our sides advice on what that liability of a pending or threatened litigation might be and how we might mitigate it. So one lesson we learned was it's very helpful to have these outside experts advising both sides on the transaction about what could be the post-merger disputes. Now, there's no way you can assure yourself that a recalcitrant partner is not going to bring a lawsuit. But one way you can mitigate that is, and this is another lesson learned, communicate, communicate, communicate. Yes, things have to be kept confidential in the process of negotiation, but all the partners should be communicated with on a regular basis so that they understand what's going to happen to them, what's going to happen to their law firm. We also realized that we had to settle known disputes before the merger. And that took quite a period of time and quite a process, an involved process, because we had some very sticky lawsuits that we had to get rid of. We appointed outside counsel to work those issues as well. And I think a final lesson we learned was it's always helpful to have a very good public relations consultant in a merger transaction. You want to make sure that your ultimate customer is informed in a timely and effective way about what is going to happen to his supplier or his law firm or what have you. But all in all, I would have to say that due diligence, a very aggressive, solid due diligence, is the best way to avoid post-merger disputes. That's, I think, our lesson learned. Thank you, Igor.
Thank you, Mr. Brand. Ну что ж.
Thank you very much. We seem to be completing our session. I apologize as a moderator that I didn't stop any of the presenters, so we outran our session for 15 minutes. But fortunately, this topic is limitless. I'm sure we all have learned a lot of positive things. This was a valuable knowledge-sharing experience. I'm sure in future we could be looking forward to more exchanges every year. year brings something new in that area. I would like to thank the panelists for their contributions and thank the audience for attention, and I wish you enjoying this legal forum. Thank you.